especially
And
since
Michael.
we have a holiday weekend coming up. I really appreciate everybody being here. I'm Ashley Campbell. I'm our subcommittee chair for the issues subcommittee to study succession planning. And I just want to welcome all of you and thank you for being here. Also thank Alice and Barry for helping us get organized and get all together. So thank you for being here as well. I thought I would start out by allowing everybody to make introductions. I think we probably all know each other, but why don't we start with our staff introductions? Alice, do you want to start? And tell us what your relationship is to the committee.
Okay, so I'm the executive director of the State Bar. I think most of y'all know me. I am right now serving as kind of the chief counsel for the committee in the sense that I'm trying to help organize everything, get meetings scheduled. I'll do the committee reports. At some point, I may pass the baton to Barry or Brian, but at this juncture where we've got a lot of new subcommittees for issues, it just felt like it was easier for me to kind of help get everything kicked off.
Thank you, Allison. Thank you for offering to do our report, which we very much appreciate. Barry?
Yes, I'm, as Alice just said, I'm helping out on the subcommittee to staff it. And I deal with trusteeships at the bar and also with client security fund issues in addition to grievance. So, thanks,
Barry. And Brian.
Hi, everyone. I'm Brian. I am your ethics counsel, and I am also staffing this subcommittee. Previously, I guess in my previous life, I was in the office of counsel, and I dealt with the trustee issues as well there. So I'm happy to be aboard here.
Thanks, Brian. And Catherine.
Thank you. So my name is Catherine Jean. I'm the counsel at the State Bar, which means that I'm responsible for everything that the Office of Counsel is responsible for, which includes trusteeships. So I'm very interested in the subject matter of the subcommittee. Thank you.
And Catherine, it's my understanding you're not really staffing our committee, but interested in our issues. So you'll be coming in as you wish. Is that right?
Well, I guess so. I plan to be at every meeting.
Okay. I'm glad you are. Great.
Yeah, I have a lot of information about just the money that the state bar has been spending on these issues. And you know, I'm just pretty familiar with the problems that we have. So I figure I might as well participate fully.
Okay. Thank you.
Yes, ma'am.
And so I'll go around the room and call out everybody else by name. And if you could let us know if you're actually on the issues committee or on the subcommittee, or if you're attending in some other role. So we'll start with Matt. Hey, Matt.
Hello, thank you, Ashley. I'm Matt Smith, Vice President. I'm here to check Brian's unfettered power that he just received from Alice.
Very important, very important. Glad you're here. Todd.
Hey, good afternoon. Sorry I'm late. I am not on this particular subcommittee. I guess ex officio wise, I'm on all committees. But I am very interested in this topic as well, since I hope to one day retire and have somebody succeed me, quite frankly. And I'm also here to keep an eye on Mr. Smith, quite frankly, that he doesn't get out of line. Thank you. Thank you for doing this, Ashley.
Yes, and thank you for joining us. We're glad you're here. Alan?
Hi, I'm Alan LaCroix. I'm the counselor from 36th District, Burke, Caldwell, and Catawba counties. And I'm on the subcommittee, as I understand. And 20 some years ago, I served as a trustee, closing out a practice of a disbarred attorney, and it was a horrible experience. It wasn't much fun.
Thanks, Alan. My husband's from Catawba County, from Newton Conover.
All right.
Great to see you. Michael?
Yes, my name is Michael Neese. I'm on the committee and I'm from Gaston County.
Great to see you, Michael. I grew up in Gaston County. Lots of connections. Good to see you. Bobby?
Hi, thank you, Ashley. Good afternoon, folks. Bobby Bowers. I'm one of the counselors from Mecklenburg County, and I am on this subcommittee.
Good to see you, Bobby. And Eben.
Hey, thanks, Ashley. I'm Eben Rawls. I'm on the Issues Committee and on this subcommittee, a counselor from Charlotte. And I will say that on at least 2 occasions, the State Bar asked me to be appointed as a trustee receiver in 2 different cases, and I declined because of the amount of work that is required to close up either a disbarred lawyer, a death of a lawyer, or some other incapacity of a lawyer, like a lawyer that fled the country leaving a mess back in the day. And my wife, who's a lawyer, she has done at least 3 and maybe 4 trustee receiverships, and it's always just been quite a chore, including one where the lawyer had not cleaned his office in 2.5 years, and she had to fight through pizza boxes, crush the keyboards, files that were not in any way organized, trust account that was a mess. And so this is a really important issue, especially looking at Alice's agenda. As some of us age out, our generation is going to be, there's going to be a tsunami of this kind of stuff. And if we don't get out in front of it, the state bar is going to be the one that has to sort of carry the load here, which can be not only burdensome, almost catastrophic in the amount of time and energy and money that's required to close out some of these older lawyers' offices. I will say this, I saw where Camille Stell had written a book on succession. I thought about buying it. It's a little pricey. It's like $69, but she's done a pretty deep dive into this. I believe she's always very thorough in what she does. All of us at the State Bar know Camille. And so, I'm hoping that we can target the small firms, the sole practitioners, the older lawyers, and kind of give them, and I will call it best practices here, but give them a checklist of things to do. And, and I've got some ideas, having worked with my wife on 2 or 3 of these very gnarly closeouts of offices. But, this is an important issue, and we need to get out in front of it.
Thank you, Evan. And then last but not least, Clark.
Well, I'm from Randolph County. I'm a sole practitioner, an aging sole practitioner. So I guess that's why I'm on the committee. And I have watched HBO Succession. So does that qualify me? I don't know.
That's what we're trying to avoid.
Yeah, I'm watching it right now, and we definitely don't want to do what they over and over and over again, right?
Well, thank you all. So glad you're all here. We have a great agenda that I think we're going to learn a lot today and then walk away with some action items. So happy about that. I just wanted to say, I was excited to be appointed as chair of the subcommittee because succession planning is actually something I've worked on quite a bit in my nonprofit board experience. And I bet many of you have also served on nonprofit boards in your community, but that's really where I began to be introduced to succession planning. I've never been asked to step in at a firm like some of you have, or dealt with it really in the legal context other than in my current job. But, succession planning is so incredibly important. If you've ever seen an organization that has one and that moves through the succession plan, you see how much the organization or the law firm in this instance benefits. And certainly the people that it serves, and in our case, the clients benefit from a succession plan. And then in the alternative, when folks don't have one, what an absolute mess it can be, like what Evan described. So I think the work that we're doing is really important, and I appreciate all of you for being engaged in it with us. So Brian has prepared a PowerPoint for us where he's going to talk about what is a succession plan and why it's important for lawyers to have one.
That's right. Thank you. And this is, meant to be an overview of just kind of what are we talking about? Let's all make sure we're talking the same language, but then also to see what the state bar does in the absence of a succession plan, and then to look at what other states are doing about this topic. So I'm going to go ahead and share my screen. Like I said, this is an overview, but this is also a conversation. So feel free to interrupt if there's any particular aspect that you want to discuss. So generally speaking, succession plans, just as far as what are we talking about, we have, as you'll see in these other states, there are a variety of, I guess, shapes that succession plans can take. Generally speaking, we're talking about a written list of instructions for a lawyer. When a lawyer becomes unavailable, perhaps they pass away, they disappear, any sort of thing, maybe they get disbarred. They just simply cannot attend to their practice anymore. If there is an existing practice, what's going to happen to that practice? A succession plan is supposed to map out just what happens to the practice, maybe naming a successor attorney that knows where the keys to the office are. They know where the passwords are. They know the organization of the office. But it basically, again, a succession plan very broadly is supposed to be this kind of map of what happens when the attorney, when an attorney becomes unavailable, simply cannot tend to their law practice anymore. And the idea is that a succession plan is going to be protecting the clients. It's a proactive measure to protect client interest, to ensure whether it's the continuity of the representation or just the ability to pass that representation off to a new lawyer and with really minimal disruption to the clients. So we have an ethical obligation actually noted in our rules of professional conduct. This is a comment to rule 1.3 that you see here. Reads comment 5: to prevent the neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each solo practitioner prepare a plan in conformity with applicable rules that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. That's a comment existing here in our rules, and really it's a comment existing in the vast majority of the states out there, their different rules of professional conduct. Notably, though, this comment really focuses on solo practitioners, but it's not. It probably shouldn't be limited to solo practitioners. And really, when we're looking at this question of, so who needs the succession plan, and really what happens when there's no succession plan in place? Law firms need to consider this. Now, large law firms have a great number of resources that they probably don't run into this as, or maybe it doesn't have as large of an impact, even though a succession plan is still needed for every lawyer, really, that's out there. But I know recently I've had the experience of talking with an attorney who was in a smaller firm, and they essentially were, they were partners. He was partners with somebody who practiced in a completely different practice area than this particular person I'm talking to. That person passed away. And now lawyer came to me and said, what am I supposed to do with all this stuff? I have no idea what was going on in this practice, but now I have a whole bunch of client files that I have to go through. I don't even know how he was organizing things. It was essentially they were agreeing to work together, but everybody did their own thing. Nevertheless, they are partners in the same firm. And generally speaking, the partners, the lawyers that are practicing together, are supposed to be responsible for each other. So, it kind of that moment, that inquiry, this conversation I had illustrated the importance of a succession plan, even for somebody who has a partner, because in that scenario, it probably would have been better for the attorney that passed away to maybe talk with another colleague that is familiar with the practice area, that knows a little bit about what is going to be needed to determine what needs immediate protective action, what does not, etc. It's the succession plan idea just should not be limited to solo practitioners, but of course solo practitioners is where we see the most impact, particularly when there's a lack of a succession plan. When there is no succession plan in place for a solo practitioner, then the state bar steps in to wind down the practice. And to be clear, I'm going over this at kind of a very surface level review, because there's going to be a lunch and learn at the April quarterly meeting just in 2 weeks on the trustee process and client security fund, to educate counselors on what the state bar does and the different resources that are available. So I'm going to leave the bulk of that to that lunch and learn, but really just so we're all on the same page here for this conversation, the state bar, yes, we step in. You probably all know that we step in to wind down practices of solo practitioners when there is no one else to wind the practice down. The State Bar Council, I believe back in 2011, officially adopted a policy or a statement that recognizes that when there's no one else available, the State Bar is in the most appropriate position to actually step in and take action under both the statutory and administrative rule setup that we have that enables the State Bar to petition the Superior Court for an appointment of a trustee to wind that practice down. And to be clear, we're winding the practice down. The trustee process closes the practice. It does not maintain the practice. It doesn't try to switch the practice over to the trustee's practice and so forth. You know, they're not trying to merge those different law offices. It's the focus of a trusteeship is to close down the practice. And that really includes notifying all the clients that they need a new lawyer and returning client property. Typically, we're talking about client files and entrusted property. But there's a number of problems with this approach. You know, certainly the State Bar does its best, but as already articulated on this call, I know Alan and Eben both hit on it. These things can be a complete mess. For one, it's hard to find trustees that are willing to step in that particular area, because of course you want somebody who's going to be local and can easily access the office. But also everyone is fully aware of you know, the potential just gigantic task that's being set before them if they're appointed as a trustee. It's a very costly endeavor. I know costs range from year to year, but there are you know, minimal fees that are paid to the lawyers that step in as trustees to compensate them for their time. Although in my experience, most of the attorneys that get appointed as trustee really probably underreport the hours that they spend. But then there's a lot of other expenses. You talk about, we need to stay in the law office, so we need to pay rent just to keep that office available, because otherwise we have to move everything out of that office into perhaps a storage unit, which we would also have to pay rent for, things of that nature. So there's a lot of different costs that go into, and it can become a very expensive endeavor. And the biggest thing that we run into, though, with this approach, when there's no succession plan and the State Bar steps in, is that these practices can be a complete mess. I know it's already been described. I've been talking about the pizza boxes that are sitting there in a law office. Like I said, in my prior life, I did some of this trustee stuff, and I had gone to a couple of different offices, sometimes when it was necessary to go and evaluate what we were looking at, and saw just the disaster that was a law office, piles of files, and seeing the different boxes, the different garbage that's around there. No idea how we actually start untangling this web that exists in a practice. Who's the active file, who's the closed file, things of that nature. It's a complex and a very lengthy process to complete. So it's really not ideal. Succession planning is where that would hopefully come in. So what exactly are we looking at? And just as just a kind of an aside, trustees appointed, we typically on a yearly basis appoint between 20 and 25 trustees. You see there was a lull in 2018, but generally speaking, we're looking at 20 to 25 trustees that are appointed. And this really is, you know, there are sometimes I will say, working with Ruth Edmondson, you know, many years ago, there are a number of times that folks would call up and, you know, they would essentially try to become kind of an informal source for clients in a local district where maybe there wasn't a whole lot of stuff to be done, where an official trustee needs to be appointed, but there still needed to be a lawyer that could just be the local point of contact if they had a question of, what am I supposed to do now? And so, you know, I know that Root would work with local lawyers in those situations where you didn't need official action, but you would still need some sort of resource to direct clients, because that was the goal, protecting clients' interests at all times. So what are we looking at for other states? Really, there's a number of approaches that you can see, and these were in your materials, particularly the ABA packet of information. They tried to do a survey of different succession plan approaches in 2019. Some of their information I'm going to update for you, but generally speaking, the ABA provides a wealth of information there. But there's three primary approaches. First, some states mandate succession planning. They require succession planning, or they require a lawyer to designate a successor through a process that they have created in the state. And I'll give you some examples shortly. The other approach is that they may have a voluntary pathway for succession planning, but the bar, provide some sort of resource, some type of opportunity for its members to actually designate a successor or file a succession plan that the bar could maintain and could reference if and when the time comes that the attorney simply cannot tend to their practice anymore. And then the last one is really kind of akin to what we have. Like I said, the vast majority of states have a comment to Rule 1.3 that recognizes the potential need to create a succession plan in the interest of protecting client interests and providing that diligent representation. That is, I'd say, like I said, the vast majority have that rule, but I think I'd also add that the majority of states rely upon just that being kind of an advisory should type of comment to the rule, as opposed to having a structure in place. So when you break it down, these are the different states that you see. We have 5 states now that are mandating succession planning: Iowa, Florida, Maine, Michigan, and New Mexico. New Mexico being the newest one. New Mexico just adopted a rule in 2021, and I'll show you that shortly. The states that offer this opportunity to designate a lawyer through the state bar system, usually it's in their annual registration process. Maybe when you go pay annual dues, you have the opportunity to plug someone's name in and say, this is supposed to be my successor attorney. If I become unavailable, people are going to come and they're going to call the state bar and ask, what happened to that practice. Delaware, Georgia, Indiana, Wisconsin, all have this in place. Louisiana has a pending rule that's before their Supreme Court right now. They have not yet acted on it, but if that rule is adopted, then it will require the Louisiana State Bar to offer this opportunity to lawyers to designate a successor attorney. And then there's a number of other states that basically provide some type of resource. They encourage succession planning, but they go beyond just having a comment in Rule 1.3. They, like California, for example, actually has a contract, a template, sort of a successor agreement that is available to all their lawyers that they can execute with another attorney. There's other states like Connecticut or Illinois. They have offered free CLEs. Illinois has an actual CLE that's available kind of all the time. I believe it's through their PMBR-esque program, but they have a CLE that's available for anyone to take who's a member of the Illinois Bar Association or registered as an Illinois attorney. Kentucky and Oregon have handbooks that contain forms, sample forms, checklists, etc. And they're very extensive handbooks. They're not just 2 or 3 pages. We're talking 40, 50, 60 pages of different considerations and so forth in their handbook. So what exactly are we looking at? Well, example of mandatory stuff, because I think this is kind of where the conversation is going to flow. What exactly do we want to do in North Carolina? So that's where the point here is to let's look at what other states are doing and specifically highlight some examples. Florida, a mandatory state, they offer a couple of different things. You can see, they have a manual in addition to mandating this. You see in their rule, this is an administrative rule of the Florida Bar, where they have basically it's their rule that articulates the Florida Bar will be the entity to seek the appointment of a trustee, similar to the process that we have here in North Carolina. But they added a provision, you see subparagraph D here, that requires an administrative requirement of the Florida Bar that each member of the bar who practices law in Florida must designate another member of the Florida Bar who has agreed to serve as an inventory lawyer under this rule, except that no designation is required with respect to anybody that's in a governmental entity and so forth. The idea is that, as you can see when you read on, that if the inventory lawyer becomes necessary, someone with the Florida Bar is going to contact that person and determine if they're still willing to serve, and basically kind of giving somebody the opportunity to say, I agreed to that before, but I don't have the time or the capability to do this now. There's an opportunity to opt out, but it still requires a lawyer at the outset to designate what they term an inventory lawyer. And that inventory lawyer in the rule basically articulates it's effectively our trustee. Then, of course, they have this manual that's available, and that has a lot of different forms and checklists, considerations for lawyers when they're trying to determine who should be their inventory lawyer and what should they do to prepare should the inventory lawyer need to step in, including this form here where they try to clearly communicate, get people on the same page and say, I've asked you to be my inventory lawyer. you've agreed to do so. So they provide not just the mandated rule or the mandatory requirement. It's also, or they also provide a number of resources for their lawyers. Iowa.
Ryan,
Yes.
can you hear me? So Alice has in the chat, is there a definition for an inventory attorney in the Florida rules?
There is, and that's where I did not include that one, but it is akin to our trustee. The inventory lawyer is supposed to be somebody who, and let me kind of back up and say that these different succession plans, one thing that's common with all of them is that they basically, the rules are, varying in their degree of specificity, but generally they are looking at, instructing lawyers to communicate with, if they have an inventory lawyer or, a successor lawyer, to communicate with this person about and provide written instructions about where files are located, who has the passwords, how do you tell active versus closed client files, what's the location and the information of your operating and your trust accounts, things of that nature, kind of those critical aspects. But the inventory lawyer in Florida is really, their definition is most appropriately compared to our trustee. They're instructed to wind down the practice, not necessarily step in and take over the practice. It is an instruction for them to basically close down the practice the way that we do here. So thank you. That's great clarification. Iowa has a similar thing. Of course, they have a requirement that each attorney in private practice must identify and authorize each year. This is an annual requirement for Iowa lawyers. As part of their questionnaire, a qualified attorney servicing or association, a law firm, or an active Iowa attorney in good standing to serve as the attorney's designated representative. And that's, you can see there in sub B, this attorney that's designated is authorized under this is their Supreme Court rules, but they're essentially their equivalent administrative rules of their Iowa State Bar, that they are authorized, this designated attorney authorized to review client files, notify each client of the attorney's death or disability, and determine whether there's a need for other immediate action to protect the interests of the clients. Again, very similar to our trustee process. Our trustees do not step into the shoes of the attorney that they are closing down the practice for, as in they take over the representation. They are supposed to inform them that clients need a new attorney. They can return client property, help them move on to their subsequent representation. And in very limited circumstances, if there's something like, the person passed away and there's a hearing the very next day, the trustee can go in and say, hey, Judge, I'm appearing as a trustee and I'm not representing this client, but I'm going to request a continuance on this client's behalf because their attorney just passed away the day before. That sort of thing. It's very limited as far as what a trustee is authorized to do in the interest of protecting clients. So that's Iowa. You look at the new one from New Mexico, 2021. This is a rule of professional conduct. This is their equivalent, or I guess what they've termed is, you see, Rule 16-119. It effectively is kind of in that. They just have a different numbering system. But the bottom line is that here, it's a part of the rules of professional conduct that New Mexico attorneys are required. They must have a written succession plan that specify the steps to be taken in the event of this lawyer's extended incapacity from practicing law, their disability, or their death. And you see here that they specifically set out that the plan must include at least the following: the identity of the person that's designated to carry out the terms of the succession plan, the location of information necessary to access the designating lawyer's current list of active clients, their client files, and other client information, and then information about the designating attorney's trust and operating account, basically the attorney that's now unavailable. So again, different formats. You see administrative rules, you see the rules of professional conduct coming into play that like New Mexico has done. They put it in their rules of professional conduct that lawyers are required to have a succession plan. And then of course you see even there it goes on. I'm only including snippets here. And we can get into the full versions if we really want to do a deep dive into some of these things. But there's a requirement for notice to be sent that, of course, the lawyer needs to notify folks who have been designated and get their consent that they are willing to serve as this successor attorney. So we have I see Matt, your question, great question. What's the penalty? And that's something that we'll probably need to discuss. To me, that's one of the considerations of, a mandatory program could be really great. It could compel folks to do the thing that we all recognize is a very necessary thing. But if somebody doesn't do it, just like is any other administrative requirement, is this something that could subject someone to, say, an administrative suspension because they don't do that? Is that something that the State Bar wants to put in place? I don't think we need to answer that question now. Maybe that's for later. We'll get through some of these other examples, but it's a great question. Georgia is one of the states that has a voluntary process, but they provide an opportunity to designate through the Georgia Bar. You see here that they basically have this notice of designated attorney where you, the lawyer, you say, I want to notify, or I want to designate Matt Smith as my successor attorney. Then I'm going to nominate him and plug his name into the Georgia database. And there's an expectation, of course, that you have discussed this with someone, whoever you're listing, you've discussed with them that I want you to be my successor attorney, and that they're willing to serve in that capacity. But again, this is not some sort of mandatory thing. It's not. This is purely voluntary for the lawyers in Georgia. I also have to say that something else that's common amongst these jurisdictions, in case anybody's wondering, I have not seen anything in any jurisdiction that basically says once you designate somebody, that's the person, no question about it. It's more so that I interpret this designation, the successor attorney, as kind of the starting point for every regulatory body to determine, okay, well, who do we go to next when we get the call that somebody has passed and clients are looking for their file? This is who we can go to. So it still has some sort of, I guess, filtering through the regulatory body in that state. And getting into other things, you see Louisiana, this is a proposed rule in Louisiana that we're wondering if they're going to approve. But this is an example where they've got the should language. Lawyers should prepare a written detailed succession plan specifying what steps must be taken in the event of their death or disability and so forth. But then you see in sub C that essentially if this gets passed, that it's requiring the Louisiana State Bar Association to maintain a registry of these succession plans or the successor attorneys, however they come to the bar. But it's something that, again, voluntary to actually execute, but it's requiring the bar there to maintain a registry of these succession plans. Resources, wide variety of resources. Like I said before, California, I think I mentioned this one, they have an agreement to close law practice in the future template. This particular agreement is not just a single page. I believe it's 7 or 8 pages. It's very thorough. Be happy to send it to you if you really want to take a look at it, but it is very thorough in trying to basically set up a situation where the California attorney can reach out to somebody else and say, hey, will you execute, or will you agree to be my practice administrator, and maybe I'll agree to be yours or something like that. But here are the different things that basically it's almost like it's an attempt to create some sort of contractual obligation. I don't know if it's an enforceable contract, but at least some sort of memorialization of this agreement to work with each other. I see, Bobby, you just asked the question of other jurisdictions considered whether there may be enough demand for a private business or a fee for service solution. I have not seen that. I have not seen that. You saw in one of the other jurisdictions, I believe it was Iowa, that referenced, that you can designate a person, a lawyer, or in good standing in Iowa, or you can designate a law firm or some association or some other administrative organization or something. That was the only time that I saw any plan or any rule that referenced something other than just simply you, lawyer, designate another lawyer in good standing in your state. So that's an interesting point. But yeah, I have not seen that widespread. Going back to these other resources, again, Illinois has some solid resources. This is the CLE resource that they have. And of course, they have some different articles and resources, paper resources for folks to review. Oregon, good old Oregon, has their handbook that was published, I believe, in 2015 about protecting your client's interest in the event of your disability or death. And they've got a number of forms within this handbook for lawyers to look at. So that brings us kind of this question of, well, what's best for us? And Ashley, I think this is where the discussion really comes in. Of course, I think, I always list that question is promoting or encouraging succession plans, is that germane to the purpose of the state bar? We always have to be mindful of that. I feel like I probably know the answer to that, or I feel like I can see the answer here. I think we've already determined at the Issues Committee that this is something that certainly does impact the provision of legal services in North Carolina and can really impact the public. So if anybody wants to talk about that, we can, but I think that we probably all agree that the answer is yes. So if so, what exactly should we do about succession planning? I think you have a number of different options to explore. There's the mandatory designation, like we're talking about, which can be very helpful, get a lot of people to do it because it's required. But anything that's mandatory needs to be enforced. And that's a question of whether or not this rises to the level of something that people should be potentially administratively suspended over if they just refuse to comply with this mandatory obligation under the bar. We can offer an opportunity to designate a successor. I think there's questions that we can explore about the State Bar's new membership portal. That's a vast improvement for lawyers to communicate information to the State Bar and to whether they can apply for specialization, they can check their CLE records, they can pay their dues. I think we do have the capability in that portal to create a different page that would allow this type of designation and just be, kind of maintained in our database. But it's going to require us to maintain that infrastructure. And that's some pretty critical information that is in the State Bar's possession there. And then, of course, resources can be a great source of information, but they also can be very timely to compose. They also need to be updated constantly based upon, developments in the practice and the law and so forth. And really, there's always that question to me of, you can make a great resource, but is it actually going to be reviewed? It might be reviewed by folks, after, unfortunately, it might be too late for someone else to actually take advantage of the resource in the direction that it offers. But still, it could be out there. It could be a great thing for the State Bar to offer. So with that said, Ashley, that's the overview that I wanted to provide. And I think we can talk. But I haven't answered any questions.
Yeah, I have 3 questions, if I could ask those. So to Bobby's question about fee for service, which was actually something I was thinking about too. Does the trustee, and I'll go to the CLE that you're doing, but does the trustee have to be a lawyer? Do they have to make appearances in court?
Yeah, the trustees are always lawyers here in North Carolina, lawyers in good standing for that matter. And I'll just the selection process for a trustee. It really starts with, it can start in a variety of spots, but usually somebody, Barry, you can weigh in on this too, of how you've been finding trustees recently. I know when I was doing it, I'd reach out to some lawyers that are in the community, usually a State Bar counselor, maybe speak to the judge. We're ultimately petitioning the senior resident Superior Court judge of that district for the appointment of a trustee. So we may reach out to a number of folks just to see who exactly could we speak with. I see Alice, you have some thoughts here.
Well, I just wanted to go back to that question of does it have to be a lawyer? And the reason for that, Ashley, is because you have to look at these files and they all include confidential client information.
Okay.
So, there might be a way to sort of finesse that. We could create some kind of exception or something, but I don't know. It has pretty significant repercussions, and I think it would be difficult to do. You have to preserve not just confidentiality, but privilege. So that's why, and that's why we get the judge to make the appointment. So basically by interposing the judiciary in there, it makes it okay that this lawyer who hasn't gotten the consent of all of these clients of the now missing lawyer to look at their information, that there's authority to do that. So that's why we think it needs to be a lawyer. If it's not going to be a lawyer, then there's a lot of work that has to be done to make that okay.
Okay. And then my second question is, so it looks like you have to do this in about 25 cases a year. I think your PowerPoint showed that you have to sort of close down or appoint a trustee in 25 cases a year. And so I was wondering, what are the current resources you're using to do that? Is that like 2 staff people? How much does it sort of cost the state bar to do all of that?
Catherine or Barry, I don't know if you want to weigh in. I know it's been a while since I've been in the office of council doing that. So maybe you'd be the more appropriate person to answer that.
I think Alice can probably speak more to how much money we're spending to pay other people, either to serve as trustees or to rent storage units and transport files and just the various expenses. We do also pay, I think it's $20 or $25 an hour for administrative assistance to the lawyers who serve as trustees. So it varies widely. I mean, I'll tell you that we have had some that were, we just had one where a lawyer was trying to get us to pay him well over $100,000. And as we parsed his invoice, we found that he had really padded his invoice, and he had also taken on these clients and provided them legal services and wanted the state bar to pay the legal fees to provide the services. So we actually ended up in a lawsuit with him. And it went on for years, and we finally settled for the amount that we would have paid all along. But it was, instead of $117,000, I think is what he was seeking, we paid him about $35,000. So that's one of the more expensive ones, I think. But Alice, do you have the figures right now?
So I was hoping I could find my February and March financials, but I don't seem to have them at my fingertips. Ashley, we've actually done pretty well. It's not come in at an outrageous figure. We're obviously not paying the lawyers that do this very much. I mean, we're paying them at the same rate that lawyers who are doing, felony cases for IDS are paid, $75 an hour. We do pay expenses. Usually that ends up being some kind of storage fee, those kinds of things. And we pay for administrative assistance too. But I think, one of our concerns is the potential that there are going to be more and more of these as the baby boomers, age out. That's a really large cohort. And so we can have more, the potential is to have more and more of these. And also the just extreme difficulty we have in finding folks to do this work. I think Evan gave you a really good example of why it's hard. It's some people like it because they like to clean up messes, but it's hard to find those people. So that's, one of the chief problems that we have. I don't think at this point, the cost to the state bar is so outrageous that, we've got to do something immediately. But we've been able to keep those costs down. The example that Catherine brought up, that's where our staff is critical. So Barry and the other folks that have done this previously, including Brian, one of the things they look at very carefully is the invoices that the trustees turn in. And they look to make sure that, the time that's taken is legitimate. The additional expenses are all legitimate. And for the most part, the lawyers who are doing this are doing it out of a sense of service as opposed to out of real, income generating activity. And we're really fortunate in that regard, because I think that when they invoice us, they usually try to keep it to a minimum, with a few exceptions that we've dealt with recently. But for the most part. So I will have my acting gear a little better next time, and we'll have the actual numbers of what we've paid for trusteeships for the last few years. Now, what my numbers show is the actual amount that we've paid to trustees. What I don't have is the staff support. Like Barry is going to be dividing his time between Client Security Fund and doing this. So, you have Barry's salary and all the overhead associated with Barry. We also have Cameron Lee is also working on this as well, right, Catherine? He's going to continue to do trusteeships, isn't he?
I think he's going to continue to do it when Barry's not available, but he's not going to continue to do it on a regular basis. And also Savannah is also a backup, because Savannah Perry has also done this. I think that they would all tell you, and Barry can probably speak to this, that the most time-consuming aspect of the staff's involvement with trusteeships is finding the trustee. And then we do have to prepare a petition, and normally we can arrange for the appointment of a trustee without having to travel to the county where the lawyer lived or was practicing. Sometimes we do have to travel and have a hearing, but most of the time, once we identify somebody, we can get the judge's approval and the appointment done without having to travel. So it's mostly just trying to find a trustee. We also have a trustee handbook that has just recently been updated that explains to the trustees what they're being called upon to do and what they are not being called upon to do, and what they can be compensated for and what they cannot be compensated for. And then the staff attorney who handles trusteeships does spend a lot of time helping the trustees. The trustee can say, I'm running into this problem. How can you help me? What do I do with this situation? And then one of the last things that we do is, if there's money left in the trust account, the trustee is called upon to try to figure out who the rightful owners are of the funds. But ultimately, if it's not apparent who the rightful owners are, then the state bar or the trustee would have to file a petition asking the court to approve a plan of distribution of those funds, which is based on our best ability to put together a jigsaw puzzle.
And I'll
Yeah, I
just
wanna-
say, the main reason, I'm sorry, Evan, I'll make this comment, then I'll defer to you. I was just going to tell y'all, the main reason I'm asking the question about like resources and cost is because, to Matt's question, I know that if we think about, when we start to talk about a mandatory rule, we're all going to think about the resources to police that rule. And so I'm just trying to get a sense of, okay, well, what are our resources now? What would they be under a mandatory rule? And would they actually end up being the same, because you may have to appoint a trustee and manage that process similarly to now? And I don't think we have to answer that question today. I just wanted you to know, I think that's at the top of mind for me. Evan, I'm sorry to interrupt you.
That's okay, Ashley. Thanks. I want to echo what Alice said, that usually, from my experience, the trustees that are appointed act out of a sense of service to the state bar. The pay is very minimal, and oftentimes cannot capture all of the time that is spent in. And I know that from firsthand experience from my wife. In the latest case she had a sprawling case out of Lincoln County. And I'm very close with the former senior resident up there. He's like family to us. And he called me and asked me to be the receiver. And I turned it over to Leslie, but she got involved with the Lafferty case, Catherine Jean, that was not only a criminal investigation. So she was having to work with the SBI and as well as with Doug Miller down at the state bar, who's phenomenal at what he does. But the trust accounting nightmares spread back all the way, I want to say, to 2003. And so much of the time was spent trying to find who owned the funds. And there was a significant amount of money that just could not be identified from the records. And so she petitioned the Superior Court judge, Don Bridges, who allowed the state bar to capture those funds that could not be identified. And I want to say that was not an insignificant amount. It was 60 grand or more. I can't remember exactly, but and I don't know what the state bar does with that, whether they put it in the client security fund or put it in some kind of trust account in case the rightful owners are able to prove their rightful ownership to those funds or not.
Well, I think what the state bar does is take one more look at it, see if we can identify the rightful claimants. And then if we cannot identify the rightful claimants, or we can identify them, but we can't reach them, we don't have any good contact information, eventually we'll need to escheat the money. But we do all of
the bar doesn't keep it. You escheat it, and you don't, because I think
right.
I could be wrong, but I thought that Judge Bridges' order allowed the state bar to, use that money.
Well, in Lafferty's case, it did, because the client security fund had paid out so many claims in Lafferty's case. I mean, so
Right.
yes, we were able to put it into the client security fund. But if there weren't client security fund claims and we can't identify the rightful claimants, then we'll ask the court for permission to escheat it, because that's what you're supposed to do under the trust accounting rules. you're not supposed to just hang
Right.
on to money that you can't identify. So it's really a case by case
Right.
basis. And that's one of the things that's interesting about trusteeships. There's not, a paint by numbers thing where it's perfectly clear what you need to do and at what point you need to do it. Every case is different. And every case has to be puzzled through, according to its own
Mhm.
circumstances.
Right.
Ashley, can I answer? I believe Clark asked a question in the chat. Clark, I think you had asked that recognize some of the models that we were looking at making kind of a civil responsibility of the estate to pay for these different costs. And there is a provision in our statute that says that the expenses of winding down the practice shall be assessed to the estate as an administrative expense
Right.
of the estate. So that's something else that, when Ashley, you're talking about the resources and so forth, and whether it's people or just the hours. And like everyone has said, I would echo from my personal experience that it varied wildly. I mean, there were some weeks where I felt like I did nothing but trustee stuff. And then it would just be kind of dry, no activity for 2 weeks. But then when you get all that stuff done, then there's that question, a very delicate question of, is this something the state bar should pursue the estate for some sort of reimbursement? And a lot of times, frankly, I feel like we saw the folks whose practice we were winding down did not have significant estates, and so it wasn't something that we're gonna have to talk over. I talked with Tom Lunsford. Is this something you want me to pursue to recover? But it looks like there's really nothing in the estate to receive any sort of compensation. But so all that's to say, yes, the statute does allow it. How often that was actually enforced or acted upon really depended upon the individual.
So we have 6 minutes left, and I know we are not going to make a decision today about whether we should have a voluntary or a not voluntary rule or a mandatory rule. What I think could be a good use of our time is to go ahead and put out, perhaps in the chat or even just verbally, what are the questions that you would want answered around these issues to help you make a decision. I'm going to put my 2 questions in the chat, and then maybe our staff support and I can work on those and get those ready for our next meeting so that we kind of come in prepared to respond to the questions or even get that information out before the meeting so that we can really, spend maybe the next hour that we're together talking about what type of rule we should have, if any. What do y'all think about that?
And folks can just, Ashley, if you would like, just have people send them to me. Don't put them in the chat because we're about to end the meeting anyway.
Okay.
So you can email them to me or Brian or both of us. And then we'll collect those and use that as a basis for the agenda for the next meeting. One thing I want to point out is the succession plans where they name, and I don't like it when they call them a successor lawyer because that sounds like they're actually taking over the practice. So what we would be suggesting is that they name, and we could be a trustee, we could be, we could come up with some name that captures the responsibility to wind the practice down and transition files appropriately to new counsel. But even with succession plans, the state bar will have to remain involved because I could name somebody who's a total mess to be my successor, right? I don't want to use that word, to handle the wind down. I mean, we don't know anything about the lawyers who are designated until we look into it. It's essentially this. I see the succession plan as giving us a head start on finding somebody to assist with the process. Hopefully a lawyer will feel enough responsibility that they'll name somebody and they will tell that person. And that person will say, yes, I'd be glad to do that for you. So that will give us a head start on that process. And then secondarily, there will be a list of things like passwords and different sort of checklist items that the lawyer has to have thought about, not just relative to who's going to handle this when I'm gone, but also what do they need to know in order to be able to handle it. And it's almost that piece of it that is as important or more important than the identification of a specific person. And I'm looking at Brian and Catherine to make sure I haven't said something that's inaccurate. But that's kind of my perception, that we want lawyers to think about it. We want to get a name or some names, but we also want to get them to think about these other issues that go along with winding down a law practice.
Alice, I'd like to weigh in just briefly here, and we may want to take this in kind of a step-by-step basis and take one of the other states' handbooks and modify it for North Carolina and start with putting that out to sort of raise awareness before we really, because it looks like we're going to dive into rule changes and things like that, and that's going to take some time. But as a stopgap measure, we may want to put out, a handbook and sort of publicize the necessity of this and give people a preliminary checklist and get people thinking about it before we just come in all of a sudden with a rule change.
I've got a number of resources, Evan, that I can share with everyone. I mean, just these handbooks that we see in Kentucky or Connecticut has something that have these different checklists, and I can put those together. Some of them are larger PDF files, so I'll work on how we transmit them all to you. But I think they can give you an overview of just what exists out there. But they're exactly what you're talking about. They're checklists. There's, kind of just a map of thinking about this process. Why is it important? But then offering some checklists to go through and some forms that you might use, even if it's something like use this form to write down who your active clients are. So you have some place to start. I think that was something that I always noticed in that trustee process of just who do you have a list of who you're currently representing? And because if you don't, somebody else could step in and they have no idea who's kind of, it needs to jump to the front of the line. So yeah.
And a list of deadlines and things to do and obligations to meet. And so, yeah, I agree.
I'd like to also suggest that maybe the committee would like to just consider, in addition to the idea of whether it's going to be required or encouraged, just launching an educational process. Whatever the other piece is that might be an action item, just launching some sort of get people to think about this. And particularly, I've ran into a situation recently where it became apparent to me that a lot of lawyers have heard that the state bar pays trustees to wind down practices. And so they don't bother to do anything because they figure the state bar will just take care of it. So we don't want to emphasize too much that we have this program so that people start to think, well, I don't need to worry about this. And I think that an educational component will be very important in that way.
I was thinking that too, Catherine, the best practices sort of educational component. So it's 2:00. So I think our next steps are to send all of your questions that you have that you'd like to have answered as you think through what is the right approach for North Carolina to Brian or Alice. To attend, if you don't already have an intimate understanding of how the trustee system works, to attend the CLE. It's a CLE in April presentation?
Yes.
Okay.
There is CLE credit for the lunch and learn.
Okay, so the lunch and learn in April. And then I noted that Brian dropped in the trustee handbook into the chat. So I just downloaded that and saved that. I'm going to take a look at that too. So might want to do that. And then we'll try to get all of those questions together and see if we can even get answers out before our next subcommittee meeting. I think our goal would be to have 2 subcommittee meetings if we can before the summer meeting. So we'll get back to everyone after the next state bar meeting to cancel our next subcommittee meeting. Any other questions or comments before we adjourn?
No, great job, Ashley.
Thank you all. And thanks Alice and Brian for being so organized today. Great information. Thanks, Brian.
Thanks, Ashley.
you.
Brian, stay on for me, okay?
Thanks,